Thanks, Jim. Thanks also to Jim Reed for inviting me. It's an honor to be here. This is my first visit to St. John's and St. Ben's, and I must say I'm tremendously impressed by the turnout that we're getting for this event on this beautiful fall afternoon. I'm told the free pizza might have had something to do with it, but I'm sure that's just incidental. And I actually can't remember the last time I spoke to a pub full of college students. Undoubtedly it happened sometime, probably in my own undergraduate days, but those days are long behind me. Jim asked me to address the topic generally of the Constitution and the environment. It's a very broad topic. I think it's also a very interesting and creative topic because we don't often think of these two things together, right? What do we think of when we think of the Constitution? If we can just have the first slide, please. Generally, we think of our great Charter of Liberties, right? The constitutional protections of civil liberties in the Bill of Rights, freedom of speech, freedom of assembly, freedom of religion, freedom of the press, guarantees of a jury trial, prohibition on self-incrimination, prohibitions against cruel and unusual punishments, and so forth. We also think about the Great Reconstruction Amendments that abolished slavery and established the principle of equal protection of the laws. That's what many of the most important ideological divisions on the Supreme Court revolve around. Much of the most heated debate about the nature of constitutional rights and constitutional liberties that end up spilling over into our electoral politics, they tend to resolve around both the Bill of Rights and the Reconstruction era amendments. But for the most part, these individual rights provisions of the Constitution, the glitzy and glamorous parts, just don't affect environmental law and environmental policy all that much, except at the remotest margins of the field. Now, there are a couple of exceptions to that. The Fifth Amendment Takings Clause, which I'm not going to address in detail here, but it does come up from time to time. Property owners, particularly landowners, object to environmental regulations that restrict their ability to use their land in the way they would like to. Advance claims that these amount to unconstitutional, uncompensated takings of their property. Occasionally, the 14th Amendment is invoked, particularly in recent years, in connection with environmental justice claims, most often advanced by racial minorities and other underprivileged groups, arguing that they're not getting equal protection of the environmental laws. Now, it turns out that for both of these kinds of claims, takings claims by property owners and equal protection claims by low-income and minority communities, the rhetorical bark of their constitutional arguments usually exceeds the legal bite. I'm not going to go into the reasons for that. You can feel free to bring it up during the question and answer and discussion period if you like. I should also mention, of course, that the due process provisions, both the due process clause of the Fifth Amendment, which applies to the federal government, the due process clause of the 14th Amendment applying to the states, are always important, particularly the 14th Amendment due process clause, which ends up incorporating just about the entirety of the Bill of Rights against the states, extending those rights that originally applied only against the federal government, and procedural due process protections requiring that government act with procedural regularity, give parties affected by government actions notice and an opportunity to be heard before their property interests are substantially affected, and so forth. But so long as government agencies adhere to what are by now pretty well established procedural norms, there's generally just not that much controversy with respect to procedural due process. In the main, I want to focus on the other, perhaps less sexy parts of the Constitution. The central part, really, the part that the framers of the Constitution spent weeks debating and fighting over in Philadelphia, the four principal articles of the Constitution in the main body of the constitutional text. The four main articles. There are also three kind of little housekeeping articles which we won't address here. The central argument at the Philadelphia Convention was not about individual rights and individual liberties. It was about a design of government. What principles were to inform the new federal government of the United States. It was about creating the three major branches of the federal government, the legislative, executive, and judicial branches, reflecting separation of powers principles. It was also, just as importantly, about the relationship between the newly formed federal government and the states. If we can move on to the next slide. The states whose existence and sovereignty predated that of the federal government and whose continued existence would remain a vital issue, both through the Constitutional Convention and in the days that followed. This Constitution, the Constitution as not our Charter of Liberties, but as our Charter of Government, profoundly shapes and constrains our efforts to protect the environment and to manage the nation's natural resources at every turn. So much so that acknowledgement of these constitutional constraints actually becomes almost second nature to environmental lawyers, to government agency managers, to advocacy groups and others involved in the policy process. We tend to simply take it for granted, right, that we're constrained, subject to these constitutional constraints. And in a way, that's probably a good thing. It means our adherence to constitutional norms and principles has become so deeply ingrained that it becomes, right, almost rote. And that says something, I think, about the enduring power of the founders' design. I think, in a way, Mr. Madison and the other framers of the Constitution would be truly impressed and probably proud of their own handiwork to see how routine and habitual our adherence to constitutional principles is today. Yet, in a way, rote adherence to any set of practices may also be a little troubling. Better perhaps to be, at least occasionally, a little self-reflective about it. What are these principles and the reasons behind what have become routine practices? To reflect on these things so that we may more faithfully carry out those principles or become more adept at adapting those principles to novel circumstances, or so that we may refine and adjust the practices in new and improved ways while remaining faithful to the guiding principles. And what better occasion to engage in that kind of reflection than this Constitution Day celebration. So what are the major constitutional principles that inform contemporary environmental law and policy? Well, there are actually quite a few of them, and I'm going to stick just to some of the main ones here in the interest of time. Some of this will already be familiar to some, or perhaps most, or perhaps even all of you. If so, please bear with me. I'll try to throw in a few additional wrinkles, even for the most seasoned Constitution watchers among you. But let's start at the beginning, as always, with the constitutional text. Next slide, please. Of course, the Constitution starts with a preamble which says absolutely nothing about the environment. And as it turns out, as inspiring and influential as these words have been, probably still doesn't say anything about the environment. We, the people of the United States, and so forth. Very powerful and visionary statement setting forth a vision of a new nation. But let's move on. Need not detain us here. Article 1, though, deserves more than a few words. Article 1 sets out the structure and powers of the legislative branch, the Congress. Again, Article 1 doesn't say anything expressly about the environment, of course, but it does lay out some very broadly worded general powers that are the ultimate source of authority for most of the environmental law and environmental policy as we know it today. Article 1, Section 8, Clause 1, the spending power. Arguably the single most important power enumerated in the Constitution. It's no accident that it comes first, right? Article 1 comes first because the framers thought the legislative branch would be the most important. In enumerating Congress's powers, the powers to tax and the powers to spend came first among those enumerated powers. The spending power is critically important in environmental law and policy, as is, to only a slightly lesser extent, the taxing power that comes with it in that very same clause. This, of course, is how Congress pays for federal agencies and departments, the EPA, the Department of the Interior, National Oceanographic and Atmospheric Administration, and so forth. It's how most of the scientific and medical research critical to our understanding of the environment and to the development of solutions to environmental problems gets funded. Sometimes Congress subsidizes environmental projects directly through direct expenditures. For example, in the 1960s and 1970s, we spent enormous sums of federal money to help municipalities build municipal wastewater systems, sewage treatment plants, which many communities simply didn't have before that. Sometimes Congress subsidizes environmental projects through indirect expenditures, so-called tax expenditures, special tax credits or tax breaks. For example, tax credits for the purchase of gasoline electric hybrid automobiles, or for weatherization of older homes, or for installation of solar equipment and so forth. Sometimes Congress acts through infrastructure investments in rail transportation or in a smart grid that will make electricity transmission more efficient. That's all, I suppose, on the plus side of environmental protection, ways that Congress affirmatively spends money or indirectly spends money through tax expenditures to promote environmentally beneficial ends. But at least as important from an environmental perspective are the government expenditures, both direct and indirect, on things that may end up harming the environment, often not intended to harm the environment, but that may often be the unintended consequence. The consequence of certain highway programs, for example. The environmental harm caused by the federal spending projects and priorities of the past and present, and indeed, efforts to undo some of those harms caused unintentionally by government spending in the past often represent some of our most difficult and challenging environmental issues today. Agriculture is an example. We wanted to help family farmers, so we spent over the years billions of dollars essentially to subsidize farmers to grow corn, encouraging farmers to grow more corn, resulting in the conversion of more and more acreage to corn production and the loss of natural native prairie habitats here in the Midwest. Then we ended up with a surplus of corn and came up with another government program to try to absorb some of that corn, and we decided to turn the corn into ethanol, a well-intentioned program, I take it, to try to reduce our dependence on foreign oil, but the result has been to further drive up the price of corn and resulting in more conversion of more acreage, more loss of native habitat, more agricultural runoff into the nation's streams and rivers. Now, I don't mean to pick on agriculture or make it the whipping boy. That's just one example. There are plenty of other examples to go around. The Bureau of Reclamation in the Interior Department, the Army Corps of Engineers have, by this time, dammed and dredged and diked almost every major river system in the United States, bringing jobs and progress in a certain way, to be sure, but at the cost of quite severe environmental harm as well. The Florida Everglades, there's a dandy example. We spent billions of dollars in the 1940s to drain the Florida Everglades, to channelize those waters in the interest of flood protection, only to discover by the 1980s or so that we were killing off environmentally sensitive wetlands at the south end of the Everglades, and now we're spending additional billions of dollars at both the federal and state level trying to undo the plumbing that we artificially put in place in the 1940s and the 1950s, just to repair the harm that came about as an unintended consequence of those well-intended government programs. I think it's no exaggeration to say that through projects carried out under the spending power and secondarily through backdoor tax expenditures, the United States government is by far the biggest despoiler of the environment in our nation today. I honestly think that's no exaggeration. And it has been for decades. It's also been the biggest protector of the environment, of course, but often the right hand and the left hand are not working in coordination. There are those who claim with, I think, some credibility that the federal government could do far more for the environment at less cost simply by getting its own house in order with respect to projects on which it's expending money than by the vast sums it spends attempting to regulate private sector actors who certainly do have an environmental impact, but whose environmental impact on the whole may be smaller than that of the federal government itself. Now, I don't want to carry that argument to the extremes that some would. So-called free market environmentalists and suggest that government ought to get out of the business of regulating private parties. I think we need both. there certainly is a whole lot more that could be done on the government expenditure side to operate government projects and programs in a way that is less harmful to the environment without sacrificing the economic development goals that accompany those programs. Let me just quickly say a couple more things here. Can I have the next slide? Okay, that's the spending clause. Okay, so the government has not entirely ignored its responsibility to try to get its own act together with respect to these programs. One of the most important, and indeed the very first of the major federal environmental statutes acted in the 1970s was the National Environmental Policy Act, our National Environmental Impact Assessment Requirements, which requires all government agencies, excuse me, prior to undertaking any project that would significantly affect the quality of the human environment, to produce an environmental impact statement detailing the environmental impacts. This is intended as a kind of a stop and think environment, directed at government agencies, saying before you undertake environmentally harmful actions or programs, stop and think about the consequences. Take stock of the environmental impacts, consider the alternatives. This certainly has made a difference for the better from an environmental protection perspective, though we certainly have a long way to go there as well. Okay, next slide, please. Sometimes government has also moved to condition federal spending programs on the achievement of environmental objectives. A simple but extremely effective example is in Department of Agriculture crop subsidy programs. We have added a provision to the Farm Bill called the Swamp Buster provision, which essentially says to farmers, you're not going to be eligible for any crop subsidies if you convert environmentally sensitive wetlands into agricultural production. It's not a direct regulatory mandate. All it is doing is conditioning federal spending on meeting these environmental standards. But from the farmer's perspective and from the environmentalist perspective, this is one of the most effective things we can do, is to tie these environmental strings to government spending and say there are certain environmental protection standards that need to be met in order for you to be eligible. Okay, so that's the spending power. Seems pretty obvious when you think about it, but I maintain this is absolutely central. This is the most important part of the ballgame here. So what else? Next slide. Okay, the Commerce Clause. Sounds pretty innocuous, right? Set aside, for our purposes, the foreign commerce part of this and the Indian commerce part of it, not because they're unimportant, but because we don't have time to address them in detail. What's left? Next slide. Congress shall have power to regulate commerce among the several states. What does that mean, and what does that have to do with environmental protection? Well, what an interesting question. Turns out this is much of our constitutional history tied up in the answer to that question. And the answer is it's contestable. It has been contested. It is contested down to the present day, and it surely will be contested in the future. And for environmental regulation, that really matters. The Commerce Clause is claimed to be the source of congressional authority for really all of our major federal environmental regulatory statutes to this day. I think it's pretty clear that certainly until the 1930s and arguably until the 1960s, none of that would have been possible under then current interpretations of the Commerce Clause. The Commerce Clause for many, many years, for decades really, was construed very narrowly. Congress could regulate things like the interstate shipment of goods. So for example, an interstate shipment of contaminated meat or an interstate shipment of contaminated rags. But it could not, the courts held, regulate economic activity occurring only in a single state. The Interstate Commerce Clause required some kind of interstate movement of goods or services in Congress. Promotion of public health and safety was thought to be the responsibility of state and local authorities, not the federal government. So federal statutes like the Clean Air Act, which is essentially a public health statute aiming to protect the health of the public by regulating the quality of the air that we breathe simply would have been considered out of bounds in those days. As would certainly the Endangered Species Act, which seeks to protect endangered species without even saying anything about what benefits those species may have for us as humans. That all changed with the New Deal jurisprudential revolution of the 1930s. Famous 1942 case, Wickard versus Filburn, upheld federal regulation of the planting of wheat on a farm by a farmer who planned to feed all of his wheat on his own farm to his own chickens. The farmer, Roscoe Filburn, said, I'm not engaged in interstate commerce. I'm just feeding my chickens on my own farm. There's no interstate commerce involved there. Supreme Court said, yeah, but if every farmer, or if thousands of farmers did exactly what Roscoe Filburn is doing, that would affect the interstate market in wheat. And that is a sufficient connection to interstate commerce to make Filburn's activities on his own land subject to federal regulation. Then along came the 60s and the civil rights and Great Society era, further expansion of government programs, again expanding the scope of the Federal Commerce Clause. The famous Heart of Atlanta motel case upheld the federal government's power to regulate public accommodations like restaurants and motels. Again, a further expansion of our interpretation of the Commerce Clause. This was accompanied at the same time by the rapid expansion of federal health and safety regulations in a variety of areas. The Consumer Product Safety Commission, the National Highway Transportation and Safety Administration, the Occupational Safety and Health Administration, and so forth. Federal government programs aimed at protecting the health and safety of individual humans. Interstate commerce, well, we adopted a very broad understanding of the scope of interstate commerce at that time. So broad that it became, I think, widely assumed that any activity, just about any activity, could be cast as having an effect on interstate commerce and consequently subject to federal regulation under the Commerce Clause. It was in that heady environment, at the height of the expansion of our understanding of the scope of the Commerce Clause, that federal environmental law came into being in a big way. In rapid succession, in the space of 10 years, we had the enactment of NEPA, the Clean Air Act, the Clean Water Act, FIFRA, our National Pesticides Law, the Endangered Species Act, the Safe Drinking Water Act, Toxic Substances Control Act, Resource Conservation and Recovery Act, CERCLA, all in the span from 1970 to 1980. The entire alphabet soup of federal environmental statutes all coming online in basically the space of a single decade, the so-called environmental decade of the 1970s. Now, the last 30 to 40 years of federal environmental law and policy in the United States have largely been about implementation of these statutes. They've become part of our everyday lives, and most of them probably just expect they are naturally there and always will be there. And that may be right. But in making that assumption, we are also committing ourselves to a particular view of the Commerce Clause. It is a view of the Commerce Clause that is not universally shared. It is a view of the Commerce Clause that may not be shared by all the members of the current United States Supreme Court. Indeed, there is some doubt as to whether it's a view of the Commerce Clause shared by a majority of the members of the current Supreme Court. The big sea change in the other direction came in 1995 with the U.S. versus Lopez case, a case having nothing to do directly with environmental law, having to do with federal regulation of handguns in the vicinity of primary and secondary schools, with Congress explicitly arguing reducing gun violence in and around schools will benefit education, and education will result in a better educated and more effective workforce. That contributes to interstate commerce. And the Supreme Court said, no, not good enough, not close enough. The connection between gun violence in the vicinity of schools and interstate commerce is too attenuated. Congress has limited enumerated powers. Congress does not have a general police power. You've got to go back and do it again. So there's going to be some real substantial and proximate connection to interstate commerce before the Supreme Court is going to approve these things going forward. Where exactly is that line? Well, the Lopez court didn't tell us. leaving it to subsequent case-by-case litigation to sort out the answer. Now, Lopez was decided 15 years ago, and so far no federal court has thrown out any major piece of federal environmental legislation on Lopez-type Commerce Clause grounds. But there's still a lot of looming uncertainty out there. Consider a couple of examples. Again, the Clean Air Act. The Clean Air Act is first and foremost a public health statute designed to improve the public health by protecting the quality of the air we breathe. A laudable goal, no doubt. But where's the commerce? And where's the interstate commerce? Is it there? Case hasn't been litigated yet. I think fertile ground for litigation by those who oppose an expansive view of the federal role in protecting the environment. This one has been litigated to some extent, the Endangered Species Act. The Endangered Species Act prohibits any person from killing or harming any member of any fish or wildlife species listed as endangered or threatened. What then about the Delhi Sands flower-loving fly, an insect species endemic to 2 counties in Southern California? No known commercial, recreational, aesthetic value. Nobody much cares about the fly, except apparently the U.S. Fish and Wildlife Service, which discovered that there were very few of them living out in the desert in Southern California, and that therefore, according to the strict statutory scientific standards, the species had to be listed, forcing a hospital, which intended to build a roadway across the Delhi Sands flower-loving fly habitat, to relocate its entire operation so as not to cause harm to the Delhi Sands flower-loving fly. I'm not making this up. This is an actual case. Decided in the DC Circuit some years ago. A 3-judge appellate panel ended up upholding the Endangered Species Act, but the 2 judges in the majority voting to uphold the statute on Commerce Clause grounds simply couldn't agree on a rationale. Judge Wald advanced a biodiversity rationale. Judge Henderson said, no, that's all wrong. That doesn't meet Commerce Clause standards. Here's my own ecosystem rationale, and they simply couldn't agree. It doesn't mean it can't be defended. It doesn't mean the Endangered Species Act ultimately won't stand up. It does suggest that we're going to see more and more of this kind of litigation going forward. There are going to be more cases like this. I'm not betting on the outcome either way, though I think it is worth noting that opponents of federal regulation have so far been disappointed that Lopez didn't give them more traction. But meanwhile, the Commerce Clause has cast a shadow on other important parts of environmental law in a less direct way, and I think I'll just try to move through this quickly and then wrap up so we can get into questions and answers and discussion. Let's see, next slide. Okay, a recent case, Solid Waste Agency of Northern Cook County versus Army Corps of Engineers. The Supreme Court narrowed the jurisdictional reach of the Clean Water Act wetlands provisions in a significant way. Pretty much from the outset of the Clean Water Act, the Environmental Protection Agency and the Army Corps of Engineers had employed what they called a migratory bird rule to claim jurisdiction to regulate wetlands that were not adjacent to navigable waterways, including isolated and headwaters wetlands that served or could serve as migratory bird habitat, arguing that we have interstate commerce in bird watching as well as bird hunting, and that this provided a sufficient Commerce Clause nexus to justify the regulation. The Supreme Court said, wait a minute, this is really pushing the outer boundaries of the Commerce Clause. We're not going to reach a constitutional holding here and hold that this kind of regulation is not permitted. But we will construe the statute, the Clean Water Act, narrowly so as not to venture into that perilous constitutional ground. We're going to apply a clear statement principle and say that unless Congress explicitly says you have to regulate these non-adjacent wetlands, then we're not going to allow the agencies to construe the statute to do so. A quite significant blow to wetlands regulation from the perspective of those who want to protect wetlands values, pretty dramatically shrinking the scope of federal wetlands regulation. And then a few years later, just in 2006, in Rapinos versus United States, again on statutory and not constitutional grounds, The Supreme Court further narrowed the scope of Clean Water Act jurisdiction over wetlands that are not adjacent to navigable, in fact, waterways. It's a kind of a technical issue of statutory interpretation that case turned on. But I think if you take these cases in combination, it signals that the present court is not happy with the expansive scope of federal environmental regulation. There may be more cases decided on statutory interpretation grounds. There surely will, at some point, be cases decided on constitutional grounds as well. So just to advert back to the big picture here, we went through a period in which the Commerce Clause was construed extremely narrowly. Then we had a fairly rapid expansion, first in the 1930s and 40s under the New Deal, and in the 1960s under the Civil Rights Revolution and the Great Society. It was at the point of greatest expansion of Commerce Clause jurisdiction that all of federal environmental law came into place. And we're now in a period, arguably, of slow retrenchment. Just how far that will go and where it will end up remains to be seen. There are a couple of other significant provisions that I'd like to talk about if I get the appropriate questions, but let's leave it there and just have an open discussion.
Okay, thank you very much. Okay, should be on. This on? Yeah, okay. We have time for question and answer, also back and forth. I should mention that this event is also co-sponsored by Target. And before I get to questions, I would like to ask, how many of you coming in here today, before you heard Bradley's speech, knew that the federal government's authority to protect the environment depended on how you read the Commerce Clause? So, people who've taken common law classes. Okay. All right. We have one microphone here. Questions, comments, thoughts? Say your name too, please.
My name is Eric. You mentioned about certain regulations have not been challenged. Do you think of a scenario that possibly something might arise that could be challenged, and if so, like the Clean Air Act, and if so, well, I guess what would be a scenario when that could be challenged?
Yeah. Okay, so the question is, when might the Clean Air Act be challenged on these constitutional grounds? I think if it is to happen at all, it's likely to come in conjunction with a challenge to a particular regulatory action that some regulated industry doesn't like, and have the constitutional argument thrown in as an argument in the alternative, or a supplemental argument to a more narrow statutory-based challenge. Well, there's not going to be litigation over the Kyoto Protocol right now because we're not a party to the Kyoto Protocol, and therefore it doesn't apply as a matter of US law. Sure, it's entirely possible to imagine. Look, the EPA is required under the Clean Air Act to regulate pollutants. The EPA has already decided under the auto emissions provisions of the Clean Air Act that greenhouse gas emissions are pollutants that endanger public health and the general welfare. Now that it has made that determination, that is likely to trigger a number of other parts of the Clean Air Act that could result in regulations being imposed on industries that are emitting greenhouse gases as part of their industrial activities. I think if and when those regulations come down, and who knows when exactly that might be, but if and when they come down, I think it's almost certain that some industries affected by that will challenge that regulatory action, both on statutory grounds, saying that it's based on an erroneous interpretation of the statute, and potentially on constitutional grounds. I think challenging the Clean Air Act on constitutional grounds is a little riskier just in terms of the kind of theatrics and politics of the thing, because the Clean Air Act is actually a pretty popular statute, and I think there's ample evidence that it has resulted in billions and billions of dollars in health savings. and in the savings of human lives, far exceeding the cost of complying with those regulations. In fact, government analyses have suggested the Clean Air Act is probably one of the most cost-effective regulatory measures the federal government has ever undertaken. But it's conceivable that some regulated industry is going to say, we just don't want it anymore.
Hi, my name is Maddie, and I'm a senior youth studies major here at St. John's. And you addressed both the legislative and judiciary branches. And I'm wondering maybe what you would say about the constitutionality of the Antiquities Act, which, for example, President Clinton used to designate significant amounts of land to state parks and protected forests, and maybe how that is in relation to the Constitution.
Okay, thank you for that question. The constitutionality of the Antiquities Act, that's, from my perspective, has the batter here, a fat pitch right down the middle. And could we move on to the next slide, please? And after this one, let's see. Okay, one more. Okay, the property clause. How many of you have ever heard of the property clause in the Constitution? Article 4, Section 3, Clause 2. This is not in the enumerated powers of Congress in Article 1. It's kind of just tacked in one of the kind of housekeeping sections of the Constitution. But the property clause says the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Now, again, this sounds pretty innocuous, right? It sounds like this is the provision that authorizes sale of military surplus and stuff. Yeah, it does that. But this is also the basis for plenary congressional power, complete congressional power over the federal public lands. Roughly 1/3 of the land in the United States. We don't often think about this in this part of the country because most land here is privately owned. But nearly 1/3 of the land in the United States is owned by the federal government. In the western United States and Alaska, it's more than that. It's about 2/3 of the land in Alaska, about half the land in the 12 westernmost states of the lower 48. What the courts have said this provision means is Congress can make pretty much any rules it darned well pleases with respect to those federal public lands. It is pursuant to that authority that, among other things, Congress enacted an Antiquities Act authorizing the president, at the president's sole discretion, to set aside portions of the public domain lands that are of particular value for scientific, cultural, historical, or other reasons. It is pursuant to that congressionally delegated authority under the Antiquities Act that in the 1990s, President Bill Clinton set aside literally millions of acres, mostly in the state of Utah, as national monuments without having to go back to Congress to get those areas designated as federal wilderness areas or national parks, and imposed regulations, quite stringent regulations, protecting the wilderness values of those areas. In my judgment, there's no doubt that the Antiquities Act is constitutional. This is one of the broadest and most unfettered grants of authority to the Congress in the entire Constitution. It says, make whatever rules you want. And it means, among other things, they can make rules to protect wildlife that preempt state law on those public lands, if and when they choose. That's been upheld by the courts. The courts have also said this extends to regulating activities occurring off the federal lands, but that have some adverse effect on the public lands. Again, a potentially very broad grant of authority that could end up affecting a lot of things should the Commerce Clause continue to retreat.
I'd just like to jump in and mention that in a certain respect, the American Civil War was fought over different interpretations of this clause. Because the question was, can Congress prevent the spread of slavery to federal territories that are not yet states? So this is another one of those clauses you probably never paid much attention to, but is potentially extremely important. Okay, someone else, question, thought?
Hello. Hi, my name is Yasmas. I'm an international student here at St. John's, poli-sci and sociology double major. And the question that I want to ask you is that I hope that everyone in this room agrees that one of the biggest pollutants in the environment is emissions created out of burning fossil fuels, non-renewable energy sources. And if the US Constitution was established to protect and ensure the greater good of the American public, why isn't the government taking steps to invest energy and time into things like renewable energy sources such as wind power, solar power, wave power, geothermal power, which is renewable and would act in the greater good of the American public?
Okay, let me say the answer to that question is primarily a political, and a policy question doesn't exactly go to the questions of the Constitution that I'm addressing here today. I do think the government is beginning to take some actions of the kind that you're describing. But ultimately, and I think it's fair to say that the executive branch currently in power, the Obama administration, would like to do more of these things. But it's subject to the laws. Laws enacted with the Constitution, and there is only so far it can go. It does not have power to appropriate funds that have not been duly appropriated by Congress. And so ultimately, it's got to get that legislation through Congress. Similarly, with respect to regulatory measures, additional regulatory measures over and above the statutes already on the books, the executive branch simply can't impose those regulations by fiat. It's got to get congressional authorization. That said, I actually know a number of people in the EPA who are working on this right now. There are people in the EPA who think EPA does have considerable unused authority under the present Clean Air Act to enact some fairly far-reaching regulations addressing greenhouse gas emissions from a variety of sources, certainly from automobiles. And that's already happening. We already have adopted. There was an endangerment finding made by the administrator of the EPA saying that greenhouse gases do endanger the public health and public welfare of the United States. That was a necessary factual predicate to then putting in place regulations that will limit the amount of greenhouse gases emitted from future generations of automobiles, new automobiles coming online in subsequent model years. So that regulation is moving forward pretty aggressively. I think we're going to see other regulatory actions probably coming out of the EPA, but it's all got to be within the bounds of the law and pursuant to standards set out in the statutes as enacted by Congress. Why doesn't Congress do more or take the problem more seriously than they have collectively up until this point? Well, that ultimately comes down to politics, I think, and I wish I had a better answer than that. But it depends on who gets elected and what kinds of interests they think they represent and what kinds of interests they decide to pursue. Ultimately a political question and not a legal one.
I'd like to jump in here with a kind of federalism question. Going back to, you mentioned how the Lopez decision, whether it was constitutional for the federal government to ban guns within school zones. And the answer was that's really a power left to the states. In that particular case, though, one of the arguments was made is that a state is just as capable, or even more capable, of regulating weapons around school zones as the federal government is. That's not necessarily the case with any of these, with the environmental protection. So can you talk about, does it make a difference constitutionally in terms of federal government versus states, whether states are actually capable of addressing these environmental challenges? Is that a constitutional, is that treated as any kind of constitutional criterion?
Okay, it's a very good and interesting question, and let me think about how I'm going to answer it. I see your point. There are certain kinds of problems that are arguably more efficiently or more effectively handled at the federal as opposed to the state or local level. Some problems arguably can't be handled at the state or local level. For example, certain kinds of interstate pollution problems, for example, pollution from a source in state A ending up in state B. State A arguably isn't going to have any kind of incentive to address that problem because the problem is exported elsewhere, and state B will be politically incapacitated from reaching into state A to address the source of the pollution. So for interstate pollution problems, we need federal intervention. The interesting thing, though, and I actually just had this conversation with the students in my environmental survey class just yesterday. A lot of the environmental problems that are addressed by federal environmental law are arguably not of that nature. Most air pollution problems, greenhouse gases aside, are actually pretty local in nature, right? We get the buildup of air pollution in and around major urban areas, which by and large tend to reside in a single state. I mean, here are the Twin Cities metro spills over a little bit into Wisconsin, but not that much. There are a few cities that clearly have a bi-state metropolitan area. But by and large, it's local effects of local sources of pollution that we're most concerned about. So I guess the first thing I want to do is sort of flip the question around a little bit and say, do we really need federal regulation for these problems? Now, a lot of people think we do. A lot of people think state regulation was ineffective, but the history actually is a little more complicated. In the 1960s, a number of states were actually moving pretty aggressively and pretty effectively to adopt environmental regulations. Not all of them. It was uneven across the country. But we didn't necessarily need to leap into environmental regulation at the federal level. We could have let it progress a little further at the state level and see how far down the road it got us. I'm not sure that there is anything in the Constitution, though, or in constitutional law doctrine that explicitly incorporates the kind of geographic matching principle that I think you're adverting to, right? So economists argue that regulation should take place at the level of government that is most closely matched to the nature of the problem. So if it's a local problem, leave it to local government. If it's a statewide problem, let the state government handle it. If it's a national level problem, then it should be the responsibility of the federal government. I don't think that principle is clearly reflected in the Constitution or in constitutional law doctrine with respect to the interpretation of the Commerce Clause or any other parts of it that I'm familiar with. But I'd have to think about that a little more before I firmly committed to that answer.
Just to follow up on that, regarding, you mentioned the takings clause earlier, and we haven't brought up the Kelo decision. So maybe in a few minutes, just explain the importance of the Kelo decision, and then not so much the policy responses at the state level, but particularly I'm interested in the legal other court challenges that have ensued after Kelo versus London.
Okay, so are people familiar with the Kelo decision? This was a Supreme Court decision that came down a few years ago, about 2007, if I recall correctly, involving an exercise of the eminent domain power by the City of New London, Connecticut. The City of New London condemned some property, including some pretty nice and well-maintained residential properties close to the center of New London, in order to make way for a large urban redevelopment project, kind of an office park in downtown New London. Suzette Kelo, owner of one of these homes, whose house had been condemned by her local government, said, wait a minute, you can't just take my property away from me and give it to some other private party just because you think that will improve the tax base. Surely that is not permitted under the United States Constitution. And the provision in which she sought refuge was the takings clause, or the eminent domain clause, which says, nor shall private property be taken for public use without just compensation. This has always been construed to mean there's got to be a public use if government's going to take the property. And Kilo's argument was, you're just turning my private property over to some other private property owner, no public use. The Supreme Court said, well, public use broadly means public benefit. There's a benefit to the citizens and taxpayers of the City of New London from increasing the tax base and generating new jobs and economic activity. Good enough, right? We'll call that public use. The decision was met with howls of protest by property owners, by property rights advocates. A lot of state legislators adopted new legislation narrowing the scope of the eminent domain power within their states. A number of state courts construed their own state constitutions to prohibit these kinds of exercise of the eminent domain power. My sense is the wind has gone out of the sails, by and large, of that anti-Kelo reaction. And while I haven't examined all of those state court decisions, or new, in some cases, new provisions added to the state constitution or ordinary state legislation addressing the scope of eminent domain, critics have suggested a lot of those changes were really just kind of cosmetic and basically a political response that ultimately didn't change things that much. But my guess is it probably varies a good deal from state to state. There's not much the states can do to affect how the federal Constitution is interpreted in this regard. But every state is free, every state court system is free to construe its own state constitution more narrowly, right, or to give more protections to property owners. And many have done so. I would guess probably at least half the states have either had new legislation, constitutional amendments at the state level, or important precedent-setting decisions by the state Supreme Courts in the wake of the Kelo decision.
Okay, we have time for one or two more, okay?
This is a follow-up.
Hit the whole mute button.
Pardon?
Hold the mute
I think you
button.
can probably hear me, am I right?
Yeah, go ahead.
I'm not bother this. I have a follow-up to your example of the air pollution. And I would argue that an example of where there is effects from pollution in one area, the source in one area that then affects another area detrimentally is the dead zone in the Gulf of Mexico.
Absolutely.
So we have the nitrates from the fertilizer that is put on the fields up here in the Midwest, down to Missouri, et cetera. The tributaries take that into the Mississippi River, et cetera. You know the end result. So, is there any sort of protection for those individuals down in Louisiana? For example, that was considered one of the reasons that Katrina did so much damage as it did is because of the dead zone. So I have a two-part. What are their recourses, if any? Do they have any recourse? And secondly, I'm wondering, as Jim had said at the beginning, the environment, we were really a very different society when this was written. So should there be, I'm not going to say a rewriting of it, but seriously a re-examination of perhaps separate issues where we don't have environmental concerns that have to be run through this Commerce Clause, which I don't fully understand.
Okay, if you don't fully understand the Commerce Clause, you're in good company, because I'm not sure anybody fully understands the Commerce Clause, though some people pretend to. With respect to the dead zone in the Gulf of Mexico, it certainly is true that there is an enormous cumulative problem. The Mississippi River and its tributaries drain probably well over half of the lower 48 states, right? Everything from the Appalachian Mountains in the east, part of upstate New York, all the way out to Montana and Wyoming and Colorado in the west, the Rocky Mountain front. All kind of a vast collection system for the midsection of the country, bringing, by and large, polluted runoff from agriculture and from urban sources and from other sources into higher and higher concentrations until it gets to the Gulf of Mexico. And we end up each summer with a dead zone in the Gulf of Mexico, an anoxic dead zone with very low oxygen levels, literally incapable of supporting life in that part of the Gulf of Mexico. So what does our federal environmental law do about that? Well, the main protection we have against that is the Clean Water Act. The Clean Water Act, I would argue, is deficient in several major respects. The most important for this purpose being that it really doesn't address what's called non-point source pollution. Polluted runoff from farms, from urbanized areas, from construction sites, from highways, and so forth. The Clean Water Act requires point sources, that is, things like municipal wastewater facilities or industrial plants that are putting pollution into the river through the end of a pipe. Those must be permitted, and those must meet fairly stringent technology-based effluent limitation standards. But with respect to non-point source pollution, polluted runoff, basically the Clean Water Act leaves it to the states to decide what to do. And most states have done little or have done not much that's been very effective. Why? Well, it's partly because in states where there are a lot of farmers tend to be a pretty effective lobby group and don't want to be subject to regulation. It's partly for just sheer lack of political will and lack of imagination. And the EPA just has not had, the EPA has had its hands full trying to get a handle on these big point source polluters. We've done a lot to wring out that kind of pollution, right? I mean, I'm old enough to remember a time when we were literally pouring untreated sewage into the nation's waterways. We don't do that anymore, right? It's not pristine when it comes out of the end of the pipe, but it's a whole lot cleaner than it used to be. We've substantially gotten at least the kind of grossest pollution from big industrial polluters under control. But the next big issue, and I've been saying this for 20 years now and still haven't seen the action, is how do we get a handle on non-point source pollution? Until we do that and build mechanisms into the statute to allow the federal government to deal with those questions effectively, I think not much is going to happen. There are a few states now that are taking some steps. I don't want to say the states are all hopeless, but most of them are pretty hopeless with respect to that. And that's a classic example of pollution problems being exported downstream, right? Out of sight, out of mind. It becomes somebody else's problem. And so the state legislature has no incentive to address it. Should the Constitution be amended to include environmental protection standards or environmental protection principles? Well, that would not be unprecedented. There are a number of countries around the world that have environmental protection provisions written into their national constitutions. I mean, one I'm familiar with is Brazil, and it sounds pretty nice and it sounds pretty impressive. I'm not sure that it means that Brazil has higher environmental standards than we do, because as with all these things, it's not just what the language in the Constitution says, it's how it's construed, how it's applied, how it's actually implemented. I think a lot of people involved in the environmental policy process here in the United States would say, maybe a nice idea, but maybe not necessary, because Congress probably has all the authority it needs if it were to take the problem seriously. And the political will that would be required to pass a constitutional amendment might better be applied to simply getting Congress to act on some urgent environmental problem like non-point source pollution that's currently not being addressed. So I think that's pretty much where I am as well. I wouldn't be opposed to a constitutional amendment, but I don't think it's the highest urgency order of business.
Okay, well, these are great issues and great questions, and we could go on for a while, but we want to give Bradley a break. Thank you very much for coming, and thank you for a absolutely